Welcome to Gas, the true story of a toxic train derailment. I'm Ron Scholl. Last time on Gas, we considered the final piece in the medical case for Alberton spill victims, the evidence for neurological or brain damage from chlorine. We now continue with Part 6, Chapters 9 and 10. Chapter 9, Bookends. Epigraph. The chlorine cloud itself was gone, long gone. Whatever it touches in the environment, it reacts with as it disappears. MRL attorney Randy Cox. Of some 200 lawsuits, only 3 made it to court. Edgar's and Walsh's, the beginning and the end, were both in district court. Neither contested liability. Only Austin in federal court contested what caused the derailment and whether MRL was negligent. That case had big consequences for Lucinda Hodges. Edgars v. MRL went to trial in 1998 on compensatory damages. Stephen and Christine Edgar and their infant child lived 2 miles up Roscoe Road, nestled in the forested flanks of Ellis Mountain, north of Ponderosa Acres. Early on April 11, 1996, the Edgars smelled a strong chlorine odor inside their house. Outside, Stephen found a thick gas cloud. Their German shepherd lay on the ground, gasping for air. Despite residing 200 feet above the river and 6 miles from the spill site, the Edgars described a 15-foot visibility outside their home, which caused immediate breathing difficulty and burning eyes. Even after general re-entry, the residual chlorine odor was still so strong as to require that their home be cleaned professionally. A forester testified that all the Edgar evergreen trees had been impacted, either by chlorine scorching, death, or damage making them susceptible to future mortality. By this account, the gas cloud had been thick within about a mile from the northeast border of the evacuation zone. As of November 1996, the family still reported respiratory, eye, emotional, and other problems. In 1998, the only contested chronic symptoms were Stephen Edgar's eye problems. Missoula ophthalmologist Dr. Rick Neumeister diagnosed Edgar with chronic dry eyes and blepharitis, with microscopic eye abrasions. Edgar had no previous history of eye problems. Neumeister also noted Edgar was chemically sensitive. At trial, Dave Torgerson of Olympus Environmental testified as MRL sought to establish a level of exposure. Since no specific readings were taken at the Edgars property on April 11, MRL painted general assumptions. Torgerson characterized the chlorine release as a drop of dye in a large bucket of water that spread and diluted. Torgerson opined that the gas safely diluted beyond half a mile from the site, based on tests days later that showed no measurable pH levels. By Torgerson's account, the town of Alberton, 2 miles from the site, received insignificant exposure. But the environmental evidence of damaged trees could not be denied. Aerial mapping showed chlorine tree bronzing far to the east, including in the Edgars area. Nevertheless, MRL sought to establish an unlikelihood for a significant gas cloud reaching the Edgar property, and that no residual exposure remained afterward. In MRL attorney Randy Cox's closing defense argument, he told the jury that after about 24 hours, the chlorine cloud itself was gone, long gone. Dave Torgerson told you chlorine is a very reactive chemical. Whatever it touches in the environment, it reacts with as it disappears. It dissipates because of the large volume of air and disappears. And once that chlorine cloud was gone, it was gone. There were no remains, Cox said. That chlorine harmlessly disappeared as it reacted was an interesting statement. The Edgars asked for $10,328 in property damage to their trees. Cox said the damage was worth $1,772. The jury awarded $10,328. The Edgars sought $150,000 for personal injuries and emotional distress. The jury awarded $28,000, plus court costs. Hodges and others saw this verdict as a clear victory for MRL and the award an injustice. MRL had offered the Edgars $40,000 in 1996 to settle their suit. Now, the Edgars' lawyers would receive at least a third of the compensation. Furthermore, no precedent for liability had been set, nor for non-chlorine exposure, nor for exposure beyond the day of initial gas release. Presumably, the testimony of Dr. Neumeister had been crucial in getting a verdict, and it had important implications for other victims, though never publicized by the media. If it had, it would have been the first public documentation of a professional diagnosis of chronic health problems for multiple victims stemming from the Alberton spill. The Eggers verdict and the evidence set the important precedent that non-classical chronic symptoms of the eyes resulted from the Alberton spill. Furthermore, residents 6 miles from the site suffered significant exposure that led to acute and chronic illness. Patrick and Linda Walsh v. MRL went to trial in 2002. Veterans of the Frenchtown Volunteer Fire Department, the Walshes were ordered by Fire Chief Scott Waldron to help evacuate Alberton without respiratory protection. The couple worked over 2 hours evacuating residents. Over the years, treating doctors diagnosed Patrick Walsh with chemical sensitivity, RADS, RUDS, corneal burns, dry eye syndrome, gastroesophageal reflux disease, memory problems, and depression, necessitating 5 daily medications. Linda Walsh had similar diagnoses, along with mebomyitis and blepharitis and more severe respiratory problems, including asthma. She had been deemed totally disabled. The real battle lay with the Walshes' respiratory injury claims. Both Walshes had been smokers prior to the spill. MRL contended that the Walshes suffered minor temporary injuries from the spill and suffered no spill-related economic losses. Plaintiffs' complaints and claimed medical conditions are wholly unrelated to chlorine gas exposure and are predominantly the result of their own lifelong smoking habits, MRL said. But MRL had to face a jury. The month before the trial, they made the Walshes an offer, good for 10 days. For Linda Walsh, $310,000, for Patrick, $40,000. In the pretrial order, plaintiffs pegged Linda Walsh's lifelong economic losses at almost $760,000, Patrick's at almost $450,000. Plaintiff attorney Ted Lyon saw it closer to $2 million total. The Walshes turned down MRL's offer, and the case went to trial for 4 days that November. Excluded was any reference to neurological injury, gastroesophageal reflux disease, and injury due to exposure to chemicals other than chlorine. Sensitivity per se was not contested. Liability had been thrown out as well as negligence. The case boiled down to whether the Walshes had been damaged by the chlorine and at what cost. The Missoulian covered only the final day of testimony and reported on the verdict, mentioning only that chlorine had spilled. MRL attorney Randy Cox told the jury, "Sometimes people have to be told again by a jury that they are not disabled. Their problems are mild and they want to get on with their lives." Though he implied the Walshes deserved nothing, Cox didn't expect them to get nothing. Setting a low bar but appearing generous, he suggested the jury give Linda $20,000 and Patrick $10,000. The Missoulian wrote, Linda Walsh, who left the witness stand wheezing Friday afternoon after an angry outburst that the judge later told the jury to ignore, said her suffering is real and entirely attributable to her chlorine exposure. "If I knew that night what my family would have went through, I never would have went out on the call," she said. "None of this was worth it," she told the jury. Walsh said she hadn't worked since the spill because of chemical sensitivity that made it difficult to even leave home. In closing, Ted Lyon said, "MRL ruined their lives. MRL has failed to accept responsibility in this case." The jury took 3.5 hours to find that the Walshes had suffered injury from the chlorine release and awarded Linda Walsh $51,130 in damages and Patrick Walsh $25,557, about 1/5 of the total MRL had earlier offered. Hodges would never forget when MRL President Bill Brodsky showed up for one of the last evacuee meetings and avowed, "We're here for the long haul. 1 year, 5 years, 10 years, we'll be here." When even the heroes of the response were called cigarette-smoking fakers, MRL had clearly given notice that they had been in it for the long haul. In between these two cases came the meat. Hodges had signed up with Lyon out of Texas, part of Griffin et al., which covered the bulk of some 87 individual clients. In 2001, after 5 long years, she anticipated the first case to come to trial, Austin v. MRL. For Hodges and many others, the Austin trial would set the standard not only for their awards, but for whether MRL would be held accountable for the derailment. It wasn't enough to get compensation for their injuries. Victims wanted the world to know, they fervently believed, that MRL could have avoided this tragic derailment. Chapter 10. Liability. Epigraph. The truth is the most convincing story told. Early in litigation, MRL attorneys explicitly stated MRL vigorously contests any liability whatsoever for the Alberton derailment. MRL President William Brodsky agreed that MRL was not responsible for the derailment. The battle over liability culminated in Austin v. MRL, but strategies developed over years and began soon after chlorine hit the air. In a remarkable National Law Journal article published in 2002, MRL's co-counsel boasted about their spring-loaded legal response. In The Art of the Win, showcasing mass catastrophe attorney David Potter of Minneapolis, Potter explained strategies. MRL hired Potter within hours of the Alberton derailment, and he immediately hired experts in derailments and rail wear to determine why the accident occurred. Potter said the best technique is to bring in the best experts from day one to help with the NTSB, the National Transportation Safety Board, because federal agency decisions could sway the jury. MRL needed to influence that sway. Within hours, Potter hired Jude Igwemizi, a Toronto engineer and expert on railwear, and later hired a metallurgist. Potter also hired derailment expert Gary Wolf of Atlanta, who was on site that week as the defense team began immediately gathering evidence to determine why and where the rail broke. "We found a piece of the rail where the break started," Potter said. "There was a hidden defect in the web of the rail. That chunk of shattered steel had the greatest value of anything at the wreck site for MRL. The site MRL fought to control over federal agencies for several days." Following the derailment, Potter devised a strategy for MRL's public response, encouraging MRL to right away act responsibly by taking care of victims' immediate needs, he said. Potter said that this initial response establishes the defendant's credibility long before any potential trial and bolsters the first theme of the defense, the theme that MRL operated responsibly. So much for the Missoulian editorialist's naive claim that MRL did not, quote, circle the wagons, summon the lawyers, and do whatever it could to limit its liability. In the years to come, the legal art of MRL's win was forged largely out of the public eye. The point of derailment was determined as railroad mile marker 154.89, generally referenced as Curve 155 or C155. Running easterly, C155 was a 1,000-foot moderate curve to the right, nearly flat. About 514 feet of a 132-pound rail on the high side was displaced, and initially only about 444 feet recovered, the NTSB reported. Colorado Fuel and Iron, CF&I, made the rail in 1968. MRL, the FRA, and the NTSB reported in June 1996 that an internal split in the head of the rail caused the derailment. MRL voiced concern over why the crack hadn't been detected earlier, such as during a contracted Sperry rail detector check in March. MRL Chief Engineer Richard Keller sent specimens of the Alberton rail to CF&I for testing. Their macro etching revealed evidence of dark areas in the metals matrix, suggesting segregations, but not necessarily inclusions or contaminants. CF&I did not think the rail quality was abnormal. The FRA called CF&I's analysis of submitted rail samples inconclusive. FRA's Lee Klaus asked Keller to send the rail to another lab, and Keller chose Technical Services Laboratory Incorporated, TSL, an independent Missouri lab. TSL Stephen Riley examined the rail fragments in August. Riley noted evidence of a vertical split head, a VSH. In a VSH, a crack in the head of the rail runs lengthwise, typically resulting in one side of the head eventually breaking off. There were no voids or gross inclusions visible to the naked eye in this area that may have initiated a VSH, Riley reported. TSL found that the fracture was due to a single load application, a sudden fracture, at least initially. Subsequent vertical crack propagation to the running surface and into the web from this initial split had occurred immediately thereafter due to multiple wheel loadings. There was no evidence of any fatigue or long-term progressive nature to the fractures, Riley wrote. As the crack reached up into the hardened layer in the head, it branched into a typical Y shape for VSH fractures that leads to failure of one or both sides of the T-shaped head of the rail. Finally, during complete failure, subsequent wheel loadings chopped the rail into fragments. Notably, the TSL report indicated that rail wear had been a big factor. Riley wrote, "The complete rail section displayed noticeable vertical head wear and significant gauge face wear. This level of wear rendered the rail susceptible to fracture due to its diminished load-bearing capacity. Because of this reduced capacity, limits on wear are typically imposed," he said. TSL found a moderate to high level of non-metallic inclusions in the fragments, though at a level considered usual for 1960s standards. The rail was overall of good quality, Riley wrote, and the nearly 30 years of service suggested that these inclusions and service loadings were not sufficient to cause fracture in new rail. Loss of material due to wear reduced the load capacity and increased susceptibility to fracture. Riley thought converging chevron patterns on fragment N33 north, the high rail, fragment marked number 33, indicated the point of origin. In sum, Riley thought, these fragments of rail failed due to a VSH, induced by service loadings on rail which exhibited head and gauge wear that had reduced its load-bearing capacity. The fact that failure occurred at borderline wear levels suggested that service loadings were near the higher end of what is typically observed in revenue service, he said. Local media made no mention of rail wear as a factor in the Alberton derailment until 1998, and only then when MRL found itself sanctioned in court. MRL's basic defense would be that the fracture developed due to an undetectable flaw in the rail and without warning. MRL could not have prevented the accident through reasonable care, they said. But the independent conclusions on rail wear presented MRL with a major legal challenge. MRL had new rail lying beside the track at the time of the accident, ready for replacement later that spring. Civil lawsuits are not about a shared concern to find the truth. They are adversarial, each side seeking victory. Within bounds, persuasion rules, and the truth is the most convincing story told. Next time on Gas, the true story of a toxic train derailment. As the litigation heats up between Montana Rail Link and spill victims, a judge sanctions MRL for withholding documents about rail wear on their line. Meanwhile, critical pieces of the failed rail are not found, and some that was found goes missing. Until then, this is Ron Scholl. Thanks for listening. This podcast is adapted from the book Gas, the true story of a toxic train derailment. Visit Amazon.com to see the 2-book series. To access support material in the book, such as maps, photos, illustrations, and video links, visit my Facebook page Gas, the true story, or watch my Gas playlist on my YouTube channel at RL Scholl.